Can you all hear me now? Good, good. It's audible and it's visible. That is a good thing. So again, like I said, I wanted to welcome you all for the immigration seminar. We have a friend today that I think has decided she is not going to stay too long, but she's my companion for pretty much the office and everything else. Say hello, Scarlett. There we go. But, you know, as I said, we started this to basically give some help, direction, and insight to those people who were going through not only the trials of the pandemic, but also dealing with issues relating to, you know, family getting stuck and other things. I'm trying to adjust the camera. There we go. And we took a break for a little bit. And during that time, I was, you know, people were trying to get emergency appointments. We had someone that contacted us who was a spouse of an H-1B visa holder who had passed away, and trying to help them find solutions. She had kids that were in high school, and to then try to find, you know, options for them it was just really, it's been, you know, to hear the stories and to hear the troubles that everyone's having to deal with has fueled our commitment to make sure that we're a resource for all of you during this very difficult time. So without any further ado, I mean, it seems like every day there is a new immigration issue that we're dealing with. So, oh gosh, I think for this I have to. There we go. So we're trying to connect with you in different ways. Different mediums have different ways in which we are able to get the information to you. There's Facebook, Twitter, Instagram, YouTube especially, and LinkedIn. And I'll talk to you a little bit about the new initiative we have in Creative Forum on Telegram, which I'm very excited about. And I'll tell you why that was so important. If you haven't been able to listen to some of our webinars, we've talked about really critical issues, from, you know, the initial COVID travel ban to postings and all sorts of, you know, modifications that people can take for H-1B posting, for perm posting, and things like that. Travel, things F1s can do and cannot do. We delve deep into what you need to look out for if you are embarking on a perm application. And I said that at this time, even though everything seems to be in, you know, haywire and turbulent, I said it's a perfect time to start your permanent residence process. And the reason is, if the administration changes, one of the first things Congress is going to do is address the backlog that we have. Now, addressing the backlog will give us a temporary reprieve where people will be able to file for their adjustment. But the backlog, just given the sheer numbers, is going to resurface itself. But if you're not even at that point where you can file the adjustment, that means the perm has to be certified. Then you won't be able to leverage that benefit. So that's something to think about. But please check out our YouTube videos and comment. I always love to hear from you. I love hearing, you know, maybe the topics you want us to cover, and share it with your friends so we can reach as many people and try to help as many folks as we possibly can. Today we're going to talk about, I'm going to try to give you some insights about the rules the USCIS is changing. Like I said, every day there is literally a new rule up the pipeline. Just yesterday they had some clarifications on O1s, which is extraordinary ability, and P1s. And they do this, they're doing this very quietly through notice and comment. They've also made it very difficult for people to get notifications of the notice and comment because they're trying to do it kind of under, under the radar. So we're going to talk about the proposed new rules and who's going to be impacted, what can they be, and what can you do now. And then the big issue everyone's facing about emergency appointments. And what are the mechanics of that if you've got a spouse or you yourself are stuck overseas. And then finally, strategies to overcome the ban on H's, L's, and J's, and so forth. So let's get started with all these critical topics. And while we're getting through this, there'll be plenty of time for question and answer, because remember, the most important person in this webinar is you. And so I want to make sure that your questions are answered. Okay, here we go. Insights on the rule change. So this, if you remember when President Trump took office, there was a big, one of the first executive orders he signed was Hire America and Buy America. And we can go into why that doesn't make any sense with the restrictive immigration rules that they're putting forth. But nevertheless, that is the cusp. The whole idea, unfortunately, the president and his administration thinks that immigration is a zero-sum game. By that I mean, you've got one person that has a job, and so that means if there's somebody unemployed, they can do that job, which doesn't work. I mean, there's tons of healthcare jobs that are open, but I'm not qualified to work in the healthcare industry. So it is not zero-sum, because you're not dealing with apples to apples. And a really good illustration of how that's hurting the economy is yesterday, about 45 Colorado diverse businesses wrote a letter to their congressional offices and said, we need business reform, business immigration reform, because it is hurting our economy post-COVID. And there was another study that Sloan put forth that talked about how it really hurts entrepreneurship. And let me make sure I got the statistics right. That immigrants are 80% more likely to start a business in the US. And the number of jobs created about immigrant-founded firms are 42% higher than native-born. So there is a cause and effect, and hopefully what we're dealing with is temporary, because in order for us to hire America and buy America, we need immigrants. So let's go on to the H-1B changes. So the H-1B, what USCIS is trying to do is restrict the immigration requirements without going through notice and comment. So one of the things that they've done is they said this rule is going to be effective immediately after it goes through a certain process. Well, they can only do that in emergent situations. Usually, an agency under the Administrative Procedures Act has to go through a period of notice and comment. They can't just summarily issue new rules, number one. Number two, what they're purporting to do is not, they can do that if no one is being harmed, like let's say, for example, they're collecting data or something of that nature where it's not really impacting an individual, then they're permitted to do that. But in a sense where they're redefining the regulations, truly that is exclusively in the purview of Congress, that's going to be problematic. So let's start with what now in the publication, they really didn't talk about exactly what they were going to, how they were going to change it. But based on some research, some background, some discussions, we were able to come up with some thoughts on what we think the changes are going to be. And in full disclosure, I've got to tell you that Ken Cuccinelli, who is our, temporary USCIS director was the Attorney General of Virginia many years ago. And when he was Attorney General of Virginia, I was his immigration special counsel. And so I do know that even then, there was a lot of restrictive immigration policies he was trying to put forth on a state level, but it didn't gain much traction. So the executive order is going to affect H-1B adjudications, and specifically, you know, we already know that the RFE and denial rates are really high, and they have removed deference for, you know, previously approved petitions. Before, if you had had a petition that was approved, either through an extension, well, particularly through an extension, when you refiled, they weren't going to re-adjudicate some of the things that were already, you know, reviewed previously that wouldn't have changed. You know, that makes sense, right? It's been adjudicated, USCIS has reviewed it. So when you come up for an extension or amendment, they will look at the new issues, but they're not going to go back and re-adjudicate the old. Well, that was one of the first things that they did away with. They said every filing is a new filing, and you don't have to give importance or deference to the previous filing, which laid the platform for the USCIS just issuing large numbers of RFEs and an extremely large number of denials. And there have been, in the adjudications, the two things really they focused on was specialty occupation and employer-employee. And we'll tell you why that's even particularly, why now are they, you know, putting forth the changes? Well, there were a lot of court cases that ruled against the USCIS, saying that, for example, the regulations state that, and we'll go into that, but the H-1B's degree has to be related to, you know, the field. It's not the degree. It's much broader than that. But they were saying, no, you know, it's got to be a specific degree. That's not in the regulations. And we've been arguing that when we've been challenging RFEs in the past. So, you know, that was outlined by the court order. And so contracts and itineraries, they were taking it to literally. I mean, if the employer can show that they've got work, because the standard is there's sufficiency of work, of course. And that came through because after the .com era, like I said, I've been practicing for over 25 years. So I've seen the whole gamut of immigration. But after the .com bust, we had a lot of employers that started benching employees without paying them. And so that gave rise through, you know, it was actually President Clinton who enacted IRA that no longer allowed for benching of H-1B workers without pay. So you have to show, the employer has to show that they've got work. But the USCIS took it to an extreme, saying, oh, you know, if you're only going to have a contract, even though you may be a $10 million company, but you've got, the contract you're submitting is only for a 2-month period, we're only going to approve it for a 2-month period. Well, the federal court said, no, that's not correct. Now, to go back to what a definition of a specialty occupation is, see if you can see it. Okay, there it is, there we go. It requires the theoretical and practical application of a body of highly specialized knowledge and requires an attainment of a bachelor's degree or higher in a specialty occupation or its equivalent as minimum entry into the occupation into the United States. So what does that mean? It means that you have to have a degree, either a 4 years bachelor's degree or the equivalent based on, you know, you can do for H-1Bs, you can do education and experience. So you are able to use 3 years of work experience if you've got a 3-year degree to make up for that 4th year. So it's got to be the equivalent of a U.S. bachelor's degree. And you've got to be doing work within that field. So there's got to be a relationship. So the job has to require a bachelor's degree, and you've got to have the equivalent of a bachelor's degree that is related to that. So that's what the definition is. They are now trying to redefine specialty occupation, and they can do that in a number of ways. Trying to make sure that, you know, one of the issues that they had really pounded on was level 1. So perhaps saying that level 1 could never be a specialty occupation. They could also try to say that, you know, outsourcing routine jobs is not a specialty occupation. They are going to try to find a way to, or they can, you know, I think if they're going to try to address the court case, they may even say that it has to be in a degree related to the work that you're doing. But like I said, they didn't provide the details, and that was probably on purpose because they were worried about maybe a court challenge, which they're going to get anyway. But that is what they are trying to do. So the goal of the specialty occupation revision is to increase obtaining the best and brightest foreign nationals for the H-1B program. So they may, you know, what they want to do in the long run is put together like a criteria, you know, looking at what degree the person has, where they got the degree. They're not going to, would be hard sold if they could do that now, but they can try to do things like make sure that the degree, instead of the field, that the degree is related to the specialty occupation. They can say, try to curb working at third-party placement, and you know, they can try to play with that level 1 wage. They've been saying for a long time that, you know, you hear the 60,000, which someone has taken a different provision of the regulations and they've plugged in the 60,000. So if you're a dependent H-1B employer, you're supposed to undertake, you know, certain additional steps, and you're exempted from taking those additional steps if either the employee that you're currently sponsoring has a master's degree or they're making 60,000 or higher. So that's where they get that 60,000 number. That's nothing to do with the H-1B program. I mean, you have elementary school teachers that are eligible. You have, you know, researchers that are eligible that may not even be making that amount, because that's, the salary is dictated by the industry and so forth. And so it's a very false narrative that getting the best and brightest is tied to a specific salary. But that is the goal as outlined in the proposed regs, and so we have to see. Employer-employee relationship. Even now, I mean, it's existed forever that the petitioner has to have an employee-employee relationship with the individual that they're sponsoring. That means they have to be able to control the work. That makes sense. So if you're a software consultancy and you're just merely taking your employee and plucking them at a third-party site without supervising their work, without any of the other, there is a list of, and it's based on the IRS list actually, of what constitutes an employee-employer relationship. And so they want to make sure that that arrangement is in place. So they've never liked it, and they keep thinking that all third-party placements are staff aug, which is not the case. We all know that, especially in the era of software development, that a lot of times you use, you know, especially if you have like you're an Anthem or a large healthcare system, and you've got legacy systems in place where there is no off-the-shelf solution for some of the IT problems or business problems that you're having, you have to get a company to specially make that. You're not going to have those .NET people or those highly, level people who have that expertise, because you don't need that all the time. And it's really interesting that the Trump Industries use, I think it's Invo systems, Invo technology systems, to provide that kind of, product software development for their hospitality industry. And it says on their website, we will come to, your offices, and, we'll customize the, solution, and we will train your employees. So whether Invo has H-1Bs or not, it's still the same premise. I mean, for these types of companies, you need to go to the client site sometimes in order to execute the case. So as I stated, this is how we think they're going to restrict the employer-employee relationship, and maybe even increase the requirement for hiring American workers. The funny thing is that for each H-1B worker that's working, so let's say you are and I only know this from what my clients tell me, that .NET individuals are very rare to find. It's hard to find somebody who can do that. But the .NET individual needs to be supported by other jobs, by other, people who are doing other functions. And so for every H-1B employee, there's probably 3 US workers that get a job. So, I mean, it's just, it's interesting. And then, the contracting and subcontracting. And all of this is just because they don't understand how the business aspect of all of this works. So these are the changes that we suspect that they will be doing, and all saying that given the economic situation that we're in, it's to protect the US workers and wages. But in order to be able to do that, you have to prove it. So it's not enough that you say it. Where's the data? And I don't think that there's any data that would be able to support it. So as I stated earlier, there's going to be a challenge. And, we could probably see that it's going to be enjoined at least until a new election, a new administration is in place, hopefully. Okay. As I said, certain salary and wage levels, and probably do something with level 1 wages to make sure that they're paying the higher wage, or they have to hire a US worker. When does it become effective? As I said, they're trying to, you can only do this in very rare circumstances where you can forego the process that's set in place by the statute, the act. It's the Administrative Procedures Act for all agencies. All agencies have to adhere to it, but there's only certain circumstances where you can forego that process that's in place, and it's an emergent circumstances. So I think that's another problem that's in place. But I think the reason they want to do this is they want to do this before the election. It's more political than anything else. So they've sent it to the Office for OMB, and there's no public comment that's available. OMB has up to 90 days, but we suspect that there's going to be a lot of pressure on them to review it sooner, probably in time for the couple of weeks before the election. What can you do now? Well, know that it's probably going to be challenged, but you want to prepare anyway, because even if you think something's going to be challenged, you've got to be strategic in what you're doing. So if you're able to, if you've got an extension within the next 6 months, file now. In fact, if you're able to file, if you're going to expire within the next 6 months, I'll talk about it in a second, fees are going to go up. So this is a good time to go ahead and get your petitions filed. Make sure you gather the information. There are really, it astounds me how people don't really understand that there are really smart, common sense ways to address issues on specialty occupation. And that is with, and if you haven't seen it, we have a webinar that just talked about this, the court cases. If you have an RFE, I tell you point by point, not holding anything back, just telling you how I respond to them on issues of specialty occupation and employer-employee relationship. The secret sauce is in the details. You want to make sure the job description is as detailed as possible, not generic, but detailed. And then you want to kind of map your background to what the job duties are. Articles, you know, that talk about the type of work that you're doing. Remember, the H-1B through the Department of Labor is using job titles that are antiquated. There are very few IT positions that are outlined in the DOT, and that's because it was 100 years old when they used those job titles. So user interface was never imagined. AI, the Internet of Things. I mean, all these things that we're dealing with now were not in place. So, you know, like smart appliances. So you have to educate them, you have to be detailed, and you have to make sure that A plus B equals C. That means you're mapping all the information. And then that your employer-employee information, you want to submit as much as you can about showing that you are actually being controlled by your employer, even if you're a third-party placement. And that's not just for, because of the new rules, that's even now. I mean, you know, at any time you want to submit that kind of information. Emergency travel. Now, there's two things people get mixed up in. There's the drop box, and there's requesting an emergency appointment. And I've been on a few forums and I've looked, and I think people get the two confused. You can only leverage a drop box. Previously, if you've had that same visa issued within the past 12 months. During COVID, the Department of State has expanded that and said you can use Dropbox if you've had that same visa in the past 24 months. If you've never had that visa before, you can't use Dropbox. You have to schedule an emergency appointment. Now, emergency appointment and expedited appointments are used interchangeably by the Department of State. And usually there are certain circumstances that have to be met. An urgent work need. Family separation has worked for a lot of people. That is, you know, the H-1B is in the US, H-4 is in India, and they've never received an H-4 visa before, or they have and their H-4 visa has expired, so they are accepting the family separation argument, even though it's not one of the ones listed. If you're an H-1B and your visa's expired, you know, one of the things you can use is get a letter from your employer. Now, when you get a letter from your employer, there's a couple of things that you have to show. You have to outline in specificity what is it that you would be doing, and they want to know what the harm would be to the US employer if you're not able to go. So you can't just say, we will be harmed. You want to say, you know, we're working on this project. It's, you know, a $500,000 project that could become a $2 million project. There are 50 people working on this project, including, you know, 35 US citizens, all of whom could be impacted. That's what I would do. I would quantify it, and I would talk about the workers that are associated with it, especially the US workers. You have to request the appointments are getting taken, so you gotta look to see where you can get the appointment. You have the ability on the DS when you're uploading your form to outline, not only outline your reason, but upload any supporting documentation for your expedite or emergency appointment. So those are some tips to get you through that. Remember that if you were trying to travel, that if you've already got a visa, you're not affected by the travel ban. If you've got advanced paroles, you're not affected by the travel ban. Spouses and children of the above are not affected by the travel ban. So if you've got If you've gotten married and you've got a valid H-1B visa, then you're not affected by the travel ban. And this is a question that people often have some confusion on. If you've originally got an H-1B visa through employer A, and you're now working for employer B, and you have traveled, you don't need a new visa from employer B. The H-1B visa from employer A, along with an approval notice from employer B, is sufficient for you to return to the United States. We have a lot of questions about that, so I wanted to make sure we have a question. So let's see what our first question is. I want to know if I am eligible for the H-1B Dropbox or not. Please go. I was in the US and my H-1B visa was valid till 2019 and submitted documents for visa extension, but unfortunately the visa extension got denied and I came back to India in October of 19. I filed a cap exemption and premium processing got approved, and just wanted to know after some exception has been given but multiple clauses are not there, I'm not sure if I'm eligible or not. Okay, let me tell you a couple of things. Number one, let me see. Yeah, so you're within you had a visa, you had an H-1B visa within the 24 months. So you're eligible for Dropbox. And that's it. If you're eligible for Dropbox, there should be no issue. The emergency appointment is only for those people who are subject to the ban or, you know, have to get a new visa. So they need an appointment. If you are eligible on the sheer notion that you are eligible for Dropbox, then you shouldn't have a problem. If you'd like, what I would do to further bolster it is maybe get a letter from your employer talking about exactly what I had stated, that it is imperative that you need to come back in. We have another question. We've got a couple of questions. So first, let me deal with the first one. The first question is, what are the documents that you can show that its family separation would be difficult? It's funny, I've seen a progression of this. So initially, people would submit documentation saying that, you know, it would be stressful or they get anxiety or something if they're separated from their family. Now, really, it's just the mere fact that they say, you know, it's going to be very difficult for us to be apart for this long a period, and they seem to be issuing it based on that. If there's anything underlying that you could submit to further strengthen that, I would do that. Like, for example, if you're able to say, you know, the person's not, you know, not feeling well, or, you know, through COVID, you know, we don't want to be separated because we don't know what will happen, and I've got no other family in the United States. You can use those, but for the most part, we've seen that just merely saying that family separation is an issue has been, you know, one that's been convincing. Next question. I was in the US for employer A. I got a 221G when I came to India for stamping in 2019. Since then, I've joined employer B and they filed my H-1B. I'm not married. I can't apply for an H-4, so how can I apply for an emergency appointment? I have an I-140 approved. Can I apply for a visitor visa? You can apply for an emergency appointment based on your approval for your second H-1B, urgent business travel need. So get your employer to file for, to send you documentation saying it's imperative that you come in and there's an urgent business need. And like I said, it should have some sort of monetary loss. Anything that you can tie to the US economy is always great. If it's about jobs, if it's about, you know, any type of loss to the company, those are the types of things that are compelling. You know, if you're working in certain sectors are, you know, like, I think infrastructure, healthcare, there we go. Critical infrastructure needs. So if you're working in any of these areas that are listed here, those would be basis for asking for the emergency, even if it's not directly, if it's indirect. You would be able to substantiate your urgent business travel, because there is an exemption for those that are working in critical infrastructure sectors. So that would be one in which you could, you know, clearly obtain your H-1B without issue. I'm going to move myself a little over to the side so that people can see the PowerPoint. The other question is, by when will the slots be open? Well, there's not, you have to request, they're not taking any appointments, if you see on their website, in 2020. There's only two ways you can get that. That's through either you're eligible for Dropbox, or you're one of the critical infrastructure sectors, or you meet one of the emergency expedite visa appointment classifications. Those are the ones that would be eligible for, you know, an appointment now. Okay. I'm just moving the questions so I can make sure that if there are other questions, I am answering them. And there are. I filed for a visitor visa extension and left the US since flights to India started before the biometric. What would be the situation of my application for a visitor visa? What is the effect on my next entry? Is it considered an overstay? Well, with regard to your previous visitor visa extension, what I would say is, you know, when you leave the United States, effectively it's null and void. You know, you'd have to process at the consulate. But here's the good thing. The good thing is that because you filed it prior to expiration, I'm going to assume that you did. I mean, you don't say that, but I'm going to assume that you did. If you file it prior to an expiration, then that means that you have you were in a stay authorized by the Attorney General. You're not in a, there's a difference, and we have, again, we've got a really good webinar on the difference between lawful status and legal status and authorized status. So if you file an extension timely, even though your current, you know, classification may have expired, you are in an authorized stay. That means you're not accruing unlawful presence. So when you apply, you know, you said you've come back before the biometrics, you would apply for a visitor. I would imagine that your visitor visa is still valid. So when you go to the port of entry, you would only you'd only need to take proof that you filed a timely extension, that you couldn't leave at the designated time because flights were not available due to the travel ban. All those things will help support the fact that you adhered to the rules, and so you shouldn't have any problem coming back in. There shouldn't be an issue. Okay, let us see what the next question is. Hello, I would like to know if I'm eligible for H-4 Dropbox. I was on an H-4 till September 30th, 2019. On October 2019, my status changed to H-1B. My earlier H-4 expired in stamping on September 29th, 2018. I traveled to India on November 4th, 2019 for my H-1B stamping, which has been stuck for 221G for 10 months. So if you want to return to the United States on an H-4, I would suggest you don't have much time, because remember, there's a 24-month window. Your last H-4 visa expired September 29th, which is my birthday, 2019. And so you would have to try to make that request for a Dropbox application for the H-4 before that time. So you want to act fast. And there are very few appointments, you know, but you would look to see where an appointment's available. But the key is you've got to secure that appointment before the 24-month period, and so you are eligible. So it's good that you're listening today, and hopefully you can get the appointment and come back on an H-4. Once you're back on an H-4, you can change status back to H-1B. You can change from an H-4 to an H-1B because you have to file for change of status, but you can do that because you have previously approved H-1B, so you're not subject to the cap. So that is the tip. Secure a Dropbox appointment immediately. Number two, after you enter the United States, change your status from H-4 back to H-1B. So hopefully that works for you. And it's good you attended today so you can act on this immediately. Can our family members travel to the US on a B1, B2 visa during this time? Is it because you're worried about the family members applying for, are these family members eligible for an H-4, or are they like your parents or sisters and other family members that are not dependent visas? Mr. Gandhi, Paran Gandhi, if you could just let me know that, then I can give you a better, you know, suggestion as to what to do. What is the procedure to procure a emergency appointment? Well, when you go ahead and file, you know, submit your DS-160, you would say that you're trying to get an emergency appointment, and they would want reasoning, and then they also want you to, you can upload documents, supporting documents as evidence of your, you know, meeting the emergency appointment requirements. Does the embassy and MDS start accepting first-time H-4 in-person application? Well, if you, okay, so there's two things. Number one, H-4, if the H-1B has a visa already, then the spouse and family members are not subject to the ban, okay? So that's issue A. Issue B is there's no appointments in 2020. So the H-4 would then try to file for an emergency appointment, family separation, you know, health reasons, you know, any of those reasons. But first-time H-4 visas can get emergency expedited appointments if you can, you know, state a reason. And like I said, family separation has been working, so that may be the way to go. Hello, attorney. Hello. Am I eligible for Dropbox if my previous stamping was not in my home country? Yes. There's no requirement that the previous stamping take place in your home country. You just have to have that previous, the visa that you're now requesting, you have to have previously been issued that visa within the 24-month window. So yes, attorney says yes. Okay. Online status of the 751 is pending for visa interview date. It's about 22 months. There's no update. What's the option to expedite the process to remove the conditions on the green card? Now, there is probably, usually when you file for an I-751, when you get the receipt notice, they give you, on the receipt notice, it'll say valid for employment and travel for 1 year. If it's 24 months, I would suggest getting a, try to see if you can get an info pass and go see them. If you want an expedite, there's got to be a basis for the expedite. I understand what your concern is. It's ridiculous to have to wait this long, but what's the basis for the expedite? If it's so you can, for work and travel, I would get an info pass to try to get them to issue or a new receipt notice or put a stamp in your passport for authorizing work and travel, and see if that helps. This administration is not very friendly towards expedite requests, so that's the challenge. Okay, parents. Okay, very good. Yes, if your parents already have a visitor visa issued, there's no bar or no restriction for them visiting you during that time. It's just the issuance of a new visa that, even though that's not part of it, it's just because they're not, there are no interview dates for 2020. But if they've already got a visa, there is no restriction for them to visit you in the United States. Anonymous, thank you so much. You are welcome. Can I use the Dropbox for H4 even though my status changed to H-1B in the 20? Absolutely, because you're not asking, even though your status changed, you're not asking for the H-1B visa. You're asking for the H-4, and the requirement is you can be issued, you are eligible for Dropbox if you have received that particular visa that you are requesting in the past 24 months. So absolutely, you can. I'm going to take 2 more questions, and then we're going to try to plow through the rest of the PowerPoint. Do we need to request for an emergency appointment during the DS I-60 filing? Yes, it's on that process. They ask for a reason for an emergency appointment, and like I said, it even gives you the ability, which is great, to you know, upload documents for that. So here are, with the ban, here are 5 ways in which you can overcome the H-1B ban. The employer has, let me, like I said, I'm going to push myself to the side. Let's close this up. Oops, no, I don't want to end the meeting. I just want to mute. Let's see if I can. There we go. Come on, catch. Okay. Let's see if I can move my face because I want you to be able to read this stuff. Here we. So I can minimize it there. There we go. There are ways in which you can, and I think there's a way in which I can split the screen. I'm scared to do this. There we go, at least for right now. The employer has a continued need for the services or labor. The individual will provide significant and unique contributions to the employer in meeting the critical infrastructure needs. The wage rate for the H-1B exceeds the prevailing wage by at least 15%. Maybe that's some insight as to what wage changes may take place. The applicant has unusual expertise in the specialty occupation, and the denial of a visa constitutes a financial hardship for the employer. This is pretty broad, you know, it's pretty broad, and I think there are ways, you know, immediately people will tell me, oh, you know, I'm not a critical need, or there's no way to show the hardship. But as you start talking to people, you're able to find out how you can do it. So I always tell folks, don't close out your options without thinking about, you know, one of the things we do is, and I've been, like I said, I've been practicing for 25 years. I think I've had, this will be our 19th year at Challa Law, but my my focus has always been not say how you can't do something, try to figure out how you can do something. And so you've been given a very broad list of ways to meet that criteria. So I think it can be met. 3 ways of coming the L1A ban. Applicant will be a senior executive manager. Applicant has substantial knowledge within the organization. Applicant will fill a critical business need for the company, meeting critical infrastructure need. Like I said, this is a pretty broad way in which someone can overcome the L1. I mean, those are the L1 categories. Those are the class. That's, in order to get an L1, you have to meet those 3 things that would exempt you from the ban. So it's kind of ridiculous. Applicants exempt from the J1. So they, you know, au pairs, caring for minor U.S. children, child care services, exchange programs to promote U.S. national interest. And U.S. national interest can be very broad. Interns to and trainees to U.S. government agencies, full-time teachers or critical foreign policy workers. So that's pretty broad. So it's basically saying we've got the ban, but actually you're not, no one is subject to the ban is basically what they're saying. Eligibility for an L-1B is applicant will provide significant and unique contributions to the petitioning company, specialized knowledge, and is specifically related to critical infrastructure needs, and applicant has substantial knowledge, which is not easily replicated. Again, if I'm filing for an L-1B and there was no travel ban, these are the things I would try to meet. So it's not like, so basically they're saying, okay, to make a certain group of people happy, we're going to say there's a travel ban, but truly there is no travel ban. And, you know, whatever you would have to do to meet the criteria to begin with is what you'd have to do to meet the exemption. So it's much to do about nothing. So I know we've got some questions. We've got 5 questions. Okay, let me see what the next slide is, and then I'll start answering questions. Very important, USCIS fees shift on October 2nd. Most substantial fee increase is citizenship. The citizenship fee, there we go. The citizenship fee increases from $640 to $1,170. So if you know of anyone that's thinking to, that meets the criteria for naturalization, tell them to file, because it's a ridiculous amount that's increasing. So on the I-129 form, it's split by visa type. It's anywhere from $555 to $850. The fees shift on October 2nd. If you have an extension that is within the 6-month window, because you can only file 6 months in advance of your expiration for most visa classifications. But if you're within that window, it's better to file before October 2nd, so you can pay less rather than waiting afterwards. The debundling of green cards, you know, they're now putting all the fees in one boat. And like I said, citizenship increases, oh my God, from a whopping $640 to $1,170. And there is a policy behind that, which is they don't want too many foreign nationals to become US citizens. There is some sort of belief that most immigrants, when they become US citizens, tend to vote Democrat, which is not the case, but that's their belief. So additional process shifts, premium processing will be calculated using, it was typically used 15 days, calendar days. Now it's going to be 15 business days, so they can get some additional time. Elimination of the return check fee. Form updates dictate payment for certain time of form. So you've got to make sure that if you're filing for something, or your attorney, that they're using the most updated form, which reflects the new fee increase. The biometrics fee is going to be incorporated into other US filing fees except for TPS. And signature confirmation, restricted delivery as a sole method of delivery of secure USCIS documents is going to be required. So let's start answering some questions. Let's see, what is the next slide? Okay, I'll talk about that in a second. Let me answer questions first. Pull those questions aside. So, okay. It says, oops, hello again. Can I submit a new DS-60 on the same petition and the employer with a different consulate? My previous DS-160 is stuck for 12 months for 221G. Well, that's especially okay if your previous one, I believe, if you're the same person, it was stuck because you had filed an H-1B. You're now going to file an H-4. So I think that's appropriate for you to file a new DS form. You're going to have to pay new fees again, but I think it's worth it to get that done. Do we have, okay, wait. The next question is, do we have to have a PhD or professional degree to qualify for an H-1B exemption, or equivalent can be counted? Let's look back on the H-1B exemption. Hold on. Okay, so the H-1B, if you're a new H-1B and you've never had if you're a new H-1B, trying to get this to move, there we go. If you're a new H-1B and you never had an H-1B visa before and you're subject to the ban, you can do this, you can overcome the ban if you employer has a continued need for your services. The individual will provide, that you'll provide significant and unique contributions for the employer to meet critical infrastructure needs. And we talked about critical infrastructure needs in the slide before. And this is going to be uploaded onto YouTube. So if you need to review the slides again, you can. But just to look at the critical infrastructure needs, there we go. Critical infrastructure needs is listed here. And this is for an H-1B. So this is H-1B critical infrastructure needs. So number 2 says the individual will provide significant and unique contributions to an employer meeting critical infrastructure needs. Doesn't have to be direct, it can be indirect. The wage rate of the H-1B applicant exceeds the prevailing wage by 15%. The applicant has unusual expertise in the specialty occupation, and the denial of a visa for the financial for financial hardship for the employer. So these are the eligibility requirements that you need to outline. And so degree is not necessarily one that would hinder your ability to get to qualify for the exemption. So the next question, not sure if this is correct or not. You're not eligible for Dropbox in India if the last one was done outside the United States, including Canada or Mexico. Well, previously it wasn't, that wasn't the case, and truly by regulation, I think we could argue that that shouldn't be the case, but I can check on that, and if you email me at info@challalaw.com, again, it is info, I-N-F-O, @challalaw.com. I will check on that and get back to you. We've got a pretty good relationship with the Indian consulates. In fact, in years past, I think 2 years straight, I actually conducted seminars for the Department of State with all the consul generals in India. So let me, email me, and we'll make sure to check to see if that policy has changed. And then a thank you. Well, you are welcome, anonymous attendee, so you are welcome. And if any of you want some detailed information about the Dropbox process, email us and I can send you kind of the memo as to what you need to do in order to, what the rules are for the Dropbox and what the eligibility is. So I can tell you what that is. If the I-751 is in process for about 2 years, can we file for citizenship if we cross the time of 3 years for the spouse? Yes, you can. You can go ahead and file for that now. And I would if you meet that. Unfortunately, because I think you said 2 years has passed since you filed, but if you've got, it's 3 years from the date that you've received the conditional green card. So if it's been 3 years since the date you received the conditional green card, you can, and if you can file before the fees go up, that's even better. And sorry, I have a follow-up question. Will I need to withdraw my 221G stuck from the DS-160 from the consulate before applying for the DS-160 at Consulate B? I don't think so, but let me check on, there's one strategy, they are expediting 221Gs, and that is one thing that they are reviewing. So I know you're going to email me on the other question about, what the process is. So in the email, reiterate this question. I'll make sure that we get the answer for you. And another thank you. You are welcome. I am, like I said, the whole purpose of doing these things was to ensure that, we are a resource for all of you and that we can answer your questions. And in doing this, I've had people, because the employer may have an attorney that they're using. And so I've even given documents for attendees to give to their attorney so that, because the attorney was telling them one particular rule which had been overturned by another rule in 2017, and I guess the attorney wasn't aware. So when the person asked the question, I sent them the new rule. I told them what they needed to do, and they were able to get it taken care of through their current attorney. So this is more about, like I said, this is for you. And so this will get back to what we have started recently. Now, when we were going through this, somebody anonymous. Thank you so much. I'm glad I attended this session. Well, I'm so glad you did too. And it would be great if, we spend a great deal of time putting this together. We try to make sure that we give you all the information on the follow-up. You would be doing me a big favor if you could, like our, YouTube videos, because like I said, they're chock full of really helpful information. And, subscribe to our YouTube videos, like us on social media, and share our, information about our next webinar. And the best way to do that, I suspect that, doing it on Facebook may be the best, but we're on all the platforms. And so, that's the best way to do it. And what I wanted to tell you is, as we were going through this process, I started joining different forums, because I wanted to know what's going on. It's different when you hear about things, but I said, let me read what challenges they have, so I can know how to address this and make sure that we've got all the information that is relevant to people. Every time I'd get up on a forum and they had a simple question, like for example, premium processing, who does it apply to? And I try to respond because I'm like, folks were freaking out. There was no clear answer. I'd get kicked out of the forum. I have been kicked out of 6 forums because nobody wants, the forums are driven by trying to, trying to get a profit off the off the process. So it really upset me because there's a lot of misinformation that is going on those forums. So I thought, okay, we're going to start one ourselves, and this is going to be for the for everyone. And I started doing it on Telegram because Telegram is a little more. There's more you can do with Telegram than you can with WhatsApp. And so it's called the Challa chats for H-1B and H-4s. And I have, dubbed it as Clarity Forum or Clarity for Hum. That means this is clarity for us, for all of you. A place where you can actually find answers. And it's not massive confusion as to, I did this and this worked and this person said this. It is, everyone having a discussion and then having a lawyer come in and say, or a law firm come in and say, look, but this is what the regulations state. Like right now, I'm part of this one WhatsApp forum, and people don't understand that the Dropbox and the emergency appointment are two separate things, that you have to qualify for Dropbox. And then you have to assess whether, so it's because the Dropbox is saying you don't need a visa appointment, but the emergency appointment means that you do need a visa appointment. So they're two separate things, and there's massive confusion. So I want to provide a place where people can go and they can talk through their issues, understand best practices, and then, have someone who's moderating to give them the, correct information. So please join our forum on Telegram. Like I said, it's Clarity for Hum. Hum means you, all of us, but mainly for all of you. And share it with your friends, because it will be different, like I said, from other forums, in that it is clearly going to be a space where you would be able to have some valid responses to your questions. Someone said, one last question, someone said, thank you for giving a response to our satisfaction level. One more question, can a spouse file a green card for their life partner? What is the difference between a spouse getting married will file a petition at the time of the green card? Is it better to wait for citizenship? Okay, someone wants to know if when you're on a green card, should you file then, or should you wait until you're married? Well, the great thing is you can file while the person is on a green card, and then when they become a U.S. citizen, you can upgrade. So you can upgrade it. It's in process, so that's what you want, right? You want the wheels kind of moving, and you want it to, you want to make sure your process is in place, and you can do that. And then when the person becomes a U.S. citizen, you just have to let, if it's at NVC, you just have to let NVC know that you have a citizenship application. Right now, NVC is slow, but I think by 2021, hopefully things will get back to some semblance of normalcy, and you will be able to upgrade it. And usually what we do is we just, to tell you the truth, we just fax in or email them the citizenship and ask that that the new classification be recognized, and they do that seamlessly. As we said, there are different ways to connect. I'd really like to connect with you guys. If you found this helpful, I mean, that's our goal, and I try to make sure that we distinguish what we're doing from what everybody else is doing, which is just whatever you can read on the news or on Google, that's what they're telling you. Well, that's not helpful. What I want to do is tell you the things that you can't Google, give you the strategies. And yes, even if you're using another lawyer, I'm okay. Because if I'm helping you, then I've achieved my goal. But if you liked our webinar, like I said, please share it with your friends, connect with us on social media. I love hearing from you. I want to hear about what your challenges are. I want to hear about the things you want to listen to. And give me ideas for, topics you'd like us to cover for the next webinar. This is for you. I've said that before and I mean it again. I've been through the process. My family's been through the process. I know it's stressful. Take a look at our recordings. Like I said, we just don't give you generalized stuff. For perm processing, I actually tell you, this is what you need to do for a successful perm. This is what you need to do. And for the RFEs, I've got evidence that you need to supply. So it's not just general stuff. These are really very good, detailed how to get through the challenges of immigration. And so, like I said, subscribe. We look forward to hearing from you. You can email us at info@challalaw.com. And until next Wednesday, I hope you all have a fun, safe weekend. I really enjoyed our time talking and connecting and answering your questions. And I look forward to seeing you again next Wednesday. I'm sorry we ran a bit over today, but next Wednesday, 12 o'clock Eastern Standard Time. I'll see you then. Till then, Lakshmi Challa says, have a great weekend.